Welcome to today's webinar. We are really pleased to be joined today by Dawson-Field and Rhys Chamberlain from Maurice Blackburn Law Firm. I'm your facilitator, Andrea Salmon, and I'll look forward to helping field some questions today. We start all our programs by acknowledging and paying respect to the traditional custodians, past, present and emerging, on whose lands we meet today, wherever we are. We acknowledge the deep feelings of attachment and the relationship of Aboriginal people to country, and we respect the cultural authority of the elders in each community. As I said, it is our pleasure to have Rhys Chamberlain and Jess Dawson-Field with us today, and I'm going to turn off my slides and let Jess turn on her camera so that we can hear what Jess has to share with us. Thanks,
Excellent.
Jess.
No worries. Thanks, Andrea. Andrea, I think Rhys is having a bit of trouble logging on, so I might ask that you perhaps send him the link again. There's always some IT difficulties. Thank you. So Andrea's very helpfully collated some questions, which I understand have been submitted for the purpose of our time this morning. And rather than go through reams and reams of law and legal principle, I thought it'd be good if we just get straight to the questions and provide that as a framework to address some of the issues that have come up during this COVID-19 situation. So as Andrea said, please submit any questions. It certainly makes it more interesting and engaging, and we're very happy to provide as much advice as we can in a very general way. So the first question that we were asked to look at was, what can my workplace ask me to do during this time? And it seems like a simple question, but it can actually be quite complicated because it depends what scheme or what part of the law is being engaged. So the first scenario, I suppose, is there is a general power in the Fair Work Act for employers to stand employees down. That stand down is distinct and separate from the stand down in relation to the JobKeeper provisions, which I'll come to shortly. I'll call that the normal stand down situation. And essentially what it means is the employer can direct you not to come to work and not pay you. That's obviously a pretty significant decision, and there's been lots of cases about that. The most recent case also found that if an employer does that, and if an employer stands an employee down and tells them not to come to work because there's no work to be done through no fault of the employer, that employee can then not access paid sick leave. So that's a very significant effect on employees. Sorry, I just got to pop up. It's probably not as relevant at the moment, where most of the focus is on JobKeeper. So in terms of the JobKeeper scheme, if your employer is in that scheme, and you're in receipt of those payments, there are a number of things that the employer can ask you to do. So one, I guess the first one is that the employer can ask you not to work on a particular day, work for a lesser period, or work for a reduced number of hours overall. They can ask you to perform other duties. They could also ask you to work at a different location. So for example, that can mean working from home or working perhaps at another office. What it does have to, if they're directing you to do that, that workplace still has to be safe and it still has to be suitable for the employee's duties. So all those three directions have to be reasonable in all circumstances. You have to be given notice of them and they have to be provided to you in writing. As well as this power to direct employees to do things, there's also this provision in the new section of the Fair Work Act, which commenced in April and is due to expire in September. The employer can make certain requests. So that's where the employer can ask you to do things and the employee can't unreasonably refuse not to do those things. So one of those requests is that the employer can ask you to work on days or times that are different to your normal days and times. The other one might be the employer can ask you to take annual leave, provided that the request doesn't result in you having less than 2 weeks annual leave on the books. The other request is that they can actually ask if you are happy to take on further training or professional development, or also engage in reasonable secondary employment. So perhaps there's another opportunity within the business that might be available. The important thing to remember in relation to all of those aspects is that those directions are only engaged if the employer is in receipt of the JobKeeper payment. It's only then that the employer has the power to direct you to do these things, or request you to do these things. So you can certainly, if you have any concerns about what your employer is asking you to do, you should certainly seek legal advice. It's not just because these provisions exist doesn't mean that they replace or override other laws, such as discrimination law, the general protections provisions in the Fair Work Act. So if some things doesn't seem right, always get advice. There's also the capacity to bring a dispute in the Fair Work Commission about these orders. And there's been a couple of cases about that, not a lot, but I expect there'll be more as time progresses. Another option or another scenario, which I think goes on well to the next question that we're being asked to look at, which is, can an employer ask someone to sign a new contract for reduced hours during this situation? So it's a tricky one. It's a tricky one because technically the employer can ask you or can offer you new terms and conditions. The question is, do you want to accept them? And it's open to you if you do or you don't, and there's all kinds of considerations that might enter into that decision. The important one is that if you don't accept them, the employer might take steps to conclude your employment or make you, or perhaps even make the position redundant. And that's something that you want to avoid. So our general approach in these situations has been that if you're asked to vary your terms and conditions, if your employer is coming to you and saying, we need you to work 4 days a week, not 5 days a week, you need to make sure that that agreement is recorded in writing and everyone's clear on what their obligations are and for how long that obligation will apply. My view is you should have maybe only for 2 or 3 months will you agree to this variation, because we don't know where the world will be in 2 or 3 months, and it's important to have an end date to any reduction in your hours or your conditions. So any document that's agreed between the parties should have a date of expiry and should have some kind of acknowledgement that effectively you will go back to your normal terms and conditions once this period finishes, that this is just for a limited set of time, for a limited purpose, and once that's resolved, everything will go back to normal. The other important consideration is that somewhere in that document or somewhere in your negotiations with the employer, you should make sure that you're recording that your leave and entitlements, so your annual leave, your sick leave, your long service leave, will continue to accrue at the normal rates in accordance with your contract. So any agreement to vary your terms and conditions should be very limited for a very particular purpose, and I think it's best to record it in writing so that everyone knows what the parties have agreed. Now, just because if it's not in writing, sometimes you can be said to agree to new terms and conditions by your conduct. So if your employer says that they want you to work 5 days a week and you don't, go down to 4 days a week and you don't register any sort of concern about that, arguably your conduct by turning up to work the next day might be seen as some kind of acceptance of that change. So if you don't accept it, you need to make that clear. But you also need to bear in mind that, if you don't accept the variation, the employer might try and take other steps in terms of your employment, arguably might try and make the position redundant. And really at this stage in this environment, it's often a negotiation between the employer and the employee about the terms and conditions on which, you might agree to reduce your hours or your salary for a very limited period of time. So in terms of, if that's a general approach, if you're under the JobKeeper scheme, the JobKeeper scheme actually, as I said before, gives employers this power to direct people to work particular hours or work less hours. And I think the view is that if you're under the JobKeeper scheme and the employer already has this power to direct you, you probably don't need to agree to something else in a contract. But as with all legal sort of argument and advice, it's certainly on a case-by-case basis. So everything I'm saying today is very general, and I think you would have to turn on the facts for each situation as to whether you would agree to a contract if you were under a contract variation if you're under the JobKeeper scheme. So the really important sort of consideration with all of this is to make sure that if you do agree to some kind of change or some kind of alteration, that you're agreeing that it will be temporary, and that when things go back to normal, that your working conditions will go back to normal, and it's a very temporary arrangement. Another question that we had was, if I'm stood down, do I have to use my annual leave, sick leave, or long service leave? So as I said before, there's a few different types of stand down. There's the normal stand down in a situation where you're not on JobKeeper, and in that predicament, you actually can't access your sick leave. There's been some recent cases about that. So unfortunately, if you're in that situation, you might not be entitled to anything. If you're on the JobKeeper scheme and you're directed not to attend work, then you should be getting the JobKeeper payments. And if you're not, then that you can certainly make a complaint to or lodge an inquiry with the ATO or the Fair Work Ombudsman, because that shouldn't be happening. In terms of whether you can ask to take a period of annual leave while you're on the JobKeeper scheme, you can make that request, and the employer should consider it in the usual terms. As I said before, the employer can actually ask you as well to consider whether to take annual leave, but you shouldn't be left with less than 2 weeks annual leave in the bank. So it's a limited capacity for the employer to direct you to access your leave in that way. Long service leave is interesting. It's usually not covered by the federal employment scheme. It's usually a state entitlement. So usually the Victorian Long Service Leave Act will apply. And that typically provides that any long service leave needs to be agreed between the employer and the employee. So you could certainly see if that's something you wanted to do, to take extra leave, you could do that. If there was a dispute about an employer asking you to take long service leave, your course would be to commence some kind of proceeding or dispute in the state magistrate's court usually. So as I said, it depends on each scenario. There's certainly different rules that apply depending on whether you're in the JobKeeper scheme or out of the JobKeeper scheme. But the overriding view is that if something doesn't look right, it might not be right, and you should get advice, because we've seen situations in our practice where employers maybe have taken advantage of the situation to try and get people to agree to contract variations that go on for more than 3 or 6 months, that mean that someone's agreeing to reduce their hours of work or their terms and conditions for an ongoing period. And in this environment, that's probably not reasonable. That's not something that you would need to sign up to. So, and I'm very happy to take questions if any come up, so please send them through. The third question we were asked to look at was a concern about being made redundant while being stood down. That's actually something that's come up quite a lot in our practice. So if you're on the JobKeeper scheme, the legislation has been very clear that a JobKeeper direction, so a direction that you not attend work while you're on the JobKeeper payments, does not amount to a redundancy. So an employer giving a direction that you don't attend work for a number of months or a number of weeks while you're on the payment doesn't mean that your position is redundant. However, during the course of a JobKeeper, the duration of the JobKeeper payment or the duration of this, crisis, an employer might themselves do some assessment about their business and reach the view that certain positions are no longer needed in the business for a variety of reasons. So if you are made redundant and you are on JobKeeper, the Act is very clear that your entitlements should be the same as what they would have been if you hadn't been on JobKeeper. So it should be based on your, if you're under a contract or an enterprise agreement, it should be based on that rate of pay. It should be, you should receive notice, you should receive your normal redundancy. It's business as usual. So if your employer is saying to you, we want to make you redundant and we're not going to pay you redundancy, not everyone's entitled to redundancy. For example, if it's a small business employer or they apply to the Fair Work Commission for a variation so that they don't have to pay redundancy, or they find you an equivalent job elsewhere. You know, there are some situations where an employer doesn't have to pay redundancy. If those don't apply, you're entitled to the redundancy. And as I say, if something doesn't look right or sound right, then you should certainly get advice, because it's a situation where you know, you need to know what your rights and entitlements are, because often redundancies can be quite significant. So in terms of if another issue that comes up quite often is people being made redundant or selected for redundancy over other people. If and the key point here is that you're just because the JobKeeper scheme is in place, or just because the employer is directing people to, you know, asking people to work from home, doesn't mean that the normal rules and laws about employment don't apply. So discrimination law still applies, unfair dismissal still applies. You know, all the framework of our legal system still applies. So if you're concerned that, you know, you're being made redundant and no one else is in the business, and you know, you think the reason is because of a health condition or because of caring responsibilities, or you're being targeted for a particular reason, you should get advice, because that might be unlawful and there might be a claim that you can access as part of that. But it's certainly not the case that, you know, our usual rights and entitlements are frozen just because we're in the crisis that COVID-19 has created. There are still avenues if you've been discriminated or if you've been terminated unfairly. So the fourth question that we had, and I'm very happy to receive any other questions, was an employer asking an individual to attend a very large gathering of about 100 staff. And I understand that that's an in-person gathering. The employer has asked this individual to attend, as well as other staff, and that person has concerns about what effect that might have on their health. So with these scenarios, and I was talking to Andrea just before about, you know, the difficulties that people have to face in terms of disclosing medical conditions or not. If it's a situation where you know, have disclosed your condition to the employer, you might take the opportunity to, you know, politely remind the employer that, you know, there is a condition that means that you're at perhaps greater risk of exposure or a more serious effect of this particular virus. And in the very limited circumstance of this event, you require some minor reasonable adjustments. And the reason that you want to be sort of quite limited in what you say is you don't want to get into a situation where the employer says, well, we have concerns that you can't do the inherent requirements of your position. Because in disability discrimination law, there's a carve out which says if an individual can't do the inherent requirements of their employment, so the core functions of their employment, then effectively their employment, the employer can terminate their employment for the reason that they cannot do the core duties. So if one of your, and I use this example often, but say for example, one of your duties is to pack shelves and lift, you know, boxes that are over 2 kilos, and you just can't do that. Arguably, the employer might say, well, you can't do the inherent requirements of your position. We're bringing your employment to an end for that reason. And in some cases, and in probably most cases, that would be protected by law, and that would be a lawful act by the employer. Now, in this scenario that we spoke about in terms of, you know, requesting reasonable adjustments, you just want to frame it in that sort of with the knowledge that that's the legal framework that you're dealing with. You don't want to make it sound as if, you know, you require ongoing adjustments that are too difficult for the employer to manage, or could open up a broader inquiry about your health and what you can and can't do at work. My approach is just make it very limited, only deal with the situation at hand, frame it in the language of being reasonable in all the circumstances. You could even use the word reasonable adjustments, because any switched on employer will pick up that you're engaging with that disability discrimination angle, because under that legislation, as well as providing this protection for employers to terminate or end employment because someone can't do the inherent requirements, there's also this right that employees have to ask for reasonable adjustments. And those have to be provided or accommodated unless it's unreasonable for the business to do so. So for a big company, you know, one of the big supermarkets or a big organization, it, you know, in my example I gave before about the person lifting the box, it might not be hard for them to find another job for that person where they only need to lift 1 kilo. But in a small business where there's no other roles, perhaps it is unreasonable to find another position to make those adjustments, and therefore the dismissal might be permitted or lawful. But in terms of this situation, putting aside whether we're even allowed to have meetings of 100 people, in this situation, I think the way to deal with it would be just to have a very sort of measured approach, just reminding the employer that, you know, you just, in this situation, require some very minor adjustments. That adjustment being you might attend by video link, or that you might dial in to the meeting, and that in all the circumstances you think this is reasonable, and if they have a different view, maybe they could let you know, but this is the approach that's you know, you've perhaps discussed with your doctor, or you've perhaps reached the view that that's the way to go because of your the fact that your condition might give rise to a more heightened risk of illness or injury by going to this large gathering. Now, you know, an employer, and this is speaking about another area of law that I don't practice in, but certainly our firm practices in, but you know, under workers' compensation, if employer has engaged in a negligent act, and that, you know, by failing to provide a safe workplace, you know, they can be liable for the costs that you and the injury that you incur because of that negligent act. So, you know, if they had knowledge that you had a predisposition to suffering a really, you know, significant form of this illness or virus, and, you know, they direct you to attend this meeting, and, you know, heaven forbid that you contract it and you get really sick, you know, they had knowledge at the time, and then they took steps. They sort of ignored the information that you gave them rather. They took steps to not provide you a safe workplace, arguably, and that could give rise to a workers' compensation argument. So there's all kinds of different considerations, but you don't want to, you know, the overriding principle is you don't want to get into a discussion where the employer can turn around and say, you can't do the job, you can't do the inherent requirements, we want to conclude your employment. And the way to do that is just to provide limited information, request, you know, the adjustments that you need, limit it to just that scenario, and I think hopefully any reasonable employer will take that on board. Now, they were all the questions that I had prepared. So, Andrea, have you got any others that have come through, or
we certainly do, Jess.
Oh, good. It was silent.
No,
okay.
And Rhys has joined us as well. Now, the people, I'm not sure about if Rhys is able to share his camera as well, and I'm hoping people are seeing you at home. So I'm not sure what's going on there, but anyway, I certainly have some questions. Hi, Rhys. Welcome.
Here I am. Can everybody hear me?
We can indeed.
Oh,
all
good.
Right.
Oh.
I apologise to everyone who's asked questions in advance because some of the questions are quite complex, and I'll see how I go with interpreting them. So just a point of clarification, please, Jess.
Yes.
Yvonne is a full-time employee.
Yeah.
How much of her unused annual leave can her employer ask her to take? Can she, so that's the question. How much can she be asked to take?
Yeah, sure. So a full-time employee, my understanding is that the employer can direct you, as long as it's reasonable, to direct you to take annual leave, but they need to leave you with at least 2 weeks in the bank. Now, if they, you know, direct you to, you know, take all your leave, and you've got lots of leave, and perhaps you've identified that there's work that can be done in the business, and, you know, you might be able to lodge a dispute with the Fair Work Commission if you think that direction's unreasonable in the circumstances. And the problem is we don't have a full body of cases to advise, you know, what the prospects are. But at the moment, that's where the law is.
What would your advice be for someone who feels that the changes their workplace has made are unfair?
Yeah, so it depends what the unfairness is, and sometimes there's unfairness that's captured by the law and that can give rise to a cause of action, and sometimes there's unfairness that the law doesn't deal with. So if you're
in this instance, it's a discrepancy between the number of days that people are being asked to work.
Okay, well, if you feel that you're being asked to work more days than other people and that's discriminatory on the basis, you know, I can't think immediately of a situation where that might happen, but if there is something where there's direct discrimination, you know, they're giving more hours to people that have kids and less hours to people that don't have kids, there might be a discrimination argument there. Or if you're being given less hours because they've made some assumption about your health condition, that could be discrimination as well. So it does depend on the facts, but there could be an argument there.
Thank you. Christine's got a question around, she actually works for a GP clinic, and so it was determined that her continuing to work was too risky. So she's been asked, and now I'm not sure, Christine, whether she's been asked to stay at home or has requested to stay at home. So the question is around, the idea is she'll go back to work when this is finished, but what is she entitled to?
So she's been asked to stay at home. Is Christine being paid while she's at home, or?
Not sure on that, but yes, so I'm going to add a comment here. My understanding is you would continue to be paid, and if your workplace is eligible for JobKeeper, they would be supported to maintain your wage through the JobKeeper payment that they receive.
Yeah, I mean, if they're on JobKeeper, they should certainly be paying you JobKeeper, regardless of if you're at work or not. And if they're not, that's a problem for them. If they're directing you not to attend work because they can't provide you with a safe workplace, you should probably have some discussions with them about if you can access, you know, personal leave, or if they're not paying you. But, you know, arguably they shouldn't be standing you down with no income because they can't provide a safe workplace at the moment.
And there'd be no reason to apply for superannuation payment or insurance in that situation?
Over to Rhys.
Look, in that situation, it's probably a bit of a tricky one around early access to super, which is probably a bit of a different question, which we can dig into, or whether there's insurance entitlements there for you to apply for. I guess in a very broad sense, you're not working due to health reasons, i.e. that you're at a higher risk of a significant impact from COVID-19 and therefore your workplace is unsafe. But beyond that, it probably would be a stretch for an insurer to say that your health condition is preventing you from working. It's actually the risk that the workplace holds. So an income protection claim might be difficult to make unless it's a policy that covers loss of earnings irrespective of your work capacity. So let's say you're made redundant, you might have a private policy which will pay loss of earnings. But generally speaking, in that scenario, if you're fit and able to work beyond the fact that there's an increased risk of a bad health outcome by going to work, then an insurance policy might not respond, I would say. In terms of early access to super, then certainly if your business or the business is eligible, and certainly if you're financially impacted as a result, so you might have been working full time, now you're essentially stood down and only receiving JobKeeper payments, for example, and that's a reduction in your income, then you've been financially impacted. There's other requirements, but the government has introduced some temporary changes to early access to your super, specifically around responding to the pandemic. So that allows for people who've been financially impacted by COVID-19 to access $10,000 from their super account balance before the end of this financial year, and a further $10,000 if they need to, or up to, let's be clear, you don't have to take out the full 10 grand, but yeah, in the next financial year, you can certainly access another 10,000 as well, if you meet the eligibility criteria. So accessing super could be an option if you're financially impacted, but certainly it doesn't necessarily mean you need to, and there's pros and cons to that as well.
Thanks, Rhys. a question from Crystal. If the employer is receiving JobKeeper, can an employee ask for unpaid leave during this period?
Oh, that's quite an interesting one. I'm not sure why you would want to, because I suppose if you were getting JobKeeper and you were being, still asked to work and you wanted to take some leave and you didn't have annual leave that you could access, or carer's leave or something, if that was the reason for your absence, that might be a situation where you would want to access unpaid leave. But I actually wonder if the employer might not be able to do so because they have this obligation to pay this amount every fortnight once they're in receipt of it. So the short answer is I don't know the answer. I think you'd probably have to have some discussions with your employer, but I would anticipate there might be problems in the scheme taking unpaid leave, like deducting the amount from JobKeeper. And you might just have to reach some kind of agreement with the employer that you just don't work that day and are paid for it possibly. Yeah, but practically I think there might be difficulties with it. I might just add in, sorry, the question before, I think it was from Fiona about annual leave. Just to be clear, the employer can ask you to take annual leave up to the amount where you're leaving 2 weeks in the bank, and you can't unreasonably refuse. So just to confirm the emphasis, they can't direct you, but they can certainly request.
Thank you.
No worries.
So in the instance where an employer is saying that the business cannot accommodate working from home, what would be considered reasonable around that? Particularly if the employee feels they can work from home?
It's a really tricky one. I mean, there's certainly jobs where, working in an emergency ward of a hospital, I mean, that's not a job, or being a nurse in a hospital, that's not a job that can be done remotely. But certainly there's lots of jobs that can be done remotely, and we've seen that more and more, the take up of it. The discussion might sort of end up a little bit, as I spoke before, about reasonable adjustments. And I think if you were able to present your employer with perhaps, a limited scenario where you need to work from home for a particular period, or you can come into the office for a limited amount of time on particular days, and perhaps that's supported by your doctor, that might be a good, option to present to them. But you just don't want to get in a situation where the employer's saying, well, part of your job is to be in the office and you can't do that, and we want to end the employment, for that reason. You just want to have more of a dialogue with the employer as opposed to pushing, a strong sort of final position. But certainly some of the benefits might be, you could be more available for client meetings because you don't have to commute, so you can be, on the phone earlier. I think presenting to the employer what the benefits are to them is really helpful, as well as highlighting, if you need reasonable adjustments for medical reasons or health reasons, highlighting those as well and having a dialogue.
Thank you. Alex has an interesting question. Am I eligible for an annual pay rise during the time of being on JobKeeper?
Oh, interesting. So I think it will depend where the source of your wage entitlement comes from. So if it comes from an enterprise agreement or award or a contract, that's going to be relevant. If you're on a contract, I don't think you should let JobKeeper stop you having your annual wage discussions, particularly if the business is still, going along as normal, and that shouldn't put a stop on it. I think there may have been some changes to some enterprise agreements and awards about reducing perhaps annual wage increases, but it would depend on the industry. So I think if it was, if the entitlement came from either of those, you'd probably need to get some more detailed advice. But if it's to do with a contract, why not have the discussion and see where it takes you?
Absolutely. Another question, Lee has, the workplace is not applying the 1.5 metre social distancing within the workplace.
Yeah.
And terrible. So the question is, and I would probably add a layer in this, it's probably an important discussion whether or not an employee has MS. But if an employee with MS, would they be best to seek a medical letter to support their working from home arrangements?
I think that always helps to have a doctor back you up. I think that's always a useful document to have. Again, I would just go back to that concern about, you know, indicating that you can't do the inherent requirements of the job, which might include being, you know, in the office. You would just want to, you know, limit it to perhaps in the current environment. You know, the office doesn't allow one, you know, there's no capacity for this 1.5 metre distancing, and this is what you require. And if that can't be provided, then, you know, working from home is the best option, you know, for a period of a few weeks or a month, and it'd be revisited, you know, at the end of that time. You just don't want to present a firm conclusion that you can't be in the office forever and a day, because, you know, that just gives the employer power to take other steps. I do wonder though, in that situation, it might be worth making a complaint to WorkSafe, because they're, you know, the regulators of health and safety in the office, in the workplace, not just the office, there's other offices, other workplaces in Victoria, and making a complaint to them and seeing what they can do. They might try and investigate it, I'm not sure, but registering concerns that way as well. Yeah.
Someone who works in retail is wondering if it's reasonable to be asked to serve customers when they're a person living with MS.
I suppose it depends, yeah, what the medical advice is and what your doctor and treaters say. If they say,
I will throw it into that. For some people with MS, it seems to depend on the medication they're on, whether they're immune compromised more than another person. So Jojo's asked that question. That might be worthwhile ringing MS Connect and talking to one of the nurse advisors. But in some respects, Jess, it doesn't overcome the concerns someone might have living with a chronic illness. We don't want people with MS to get COVID-19 because they're dealing with more.
That's right. Then you'd think a reasonable employer would want to prevent that as well. I mean, one option might be, and I've seen this in a lot of retail spaces, you know, that they've got barriers up between customers, or, you know, if there's any modifications that can be made to the environment that mean you could go to work, maybe having a discussion about that. But if they just can't provide a safe workplace, then having some discussions with your doctor about, you know, can you be there? You know, should you be there? Is it going to affect your health? And then I guess engaging with the employer in a way that says, I just need some reasonable adjustments for this particular period, and once it's over, I can do the job absolutely. And whether there's anything in the head office, you know, the retail department or the stock room or somewhere that you don't have to be exposed to customers as much, having discussions like that. But it's very difficult, I think, in a retail environment.
Absolutely. And someone's also popped in a comment about what are the options to return to an office environment that does hot desking. So my immediate Go on.
I think this might be the end of hot desking, because it's just, there's no way to, unless you're cleaning the desks every, you know, 3 hours or 4 hours, there's no way to provide a safe environment for people. I mean, if it's a hot desking environment, maybe it's a job that's also can be done working from home. And if that's available, maybe having discussions about that. Or maybe your reasonable adjustment is that you just need to have one desk, and that so that you can manage your work environment and manage the space and know that it's, you know, hygienic and, you know, clean to as the best that you can make it. And if that's the case, then, you know, getting some supporting evidence from your doctor if they agree, and having that discussion with the employer.
Absolutely. Yvonne's got a question about what should she do if she is made redundant? What should she say or not say, and should she seek legal advice?
Yeah, great question. So when you are made redundant, one thing to keep an eye on is, you know, sometimes the employer offers deeds of releases, you know, or a contract to redundant employees and says, sign this, we'll give you a redundancy and a bit extra, and everyone walks away. If you're being asked to sign that, you should definitely get some advice, because there might be other claims. If you think the redundancy is not genuine, so if you think you're being targeted for redundancy, or if you think, you know, over other people or over other staff, or if you're being, or if the business, you know, clearly needs your role to be done, if there's any arguments around that and you're under the unfair dismissal cap, which is, I think about, I think it's 148,000, but don't quote me on that. If you're under that income protection cap, you might have access to an unfair dismissal claim. So I do think if you think there's anything funny about the process or the reason you were selected, I think you should get advice. More generally, don't sign anything, you know, without legal advice. And I think in terms of what you ask, maybe just ask why and get some information, because that might help any legal claim down the track. And the other thing you should check too, sorry, is where your redundancy entitlement comes from. So sometimes it can be in a contract, sometimes it can be in the Fair Work Act, sometimes it can be in an enterprise agreement. So if you think the amount doesn't look right, then you should also get advice about the quantum that they're offering you. Yeah.
Thank you. In regard to the superannuation changes that were made because of COVID-19 that allows people to access their super, should people be accessing their super?
Well, good question. I think it depends on the people entirely. So, look, there's some pros and cons there, and obviously there's certain eligibility criteria about who can access that chunk of money from your super. The information on that's available on the ATO website, and certainly we've got information on the Maurice Blackburn website as well, and applications are made via the MyGov portal. But as to whether you should or shouldn't, look, there's some positives around accessing your super. First of all, it's a relatively fast process. The funds are really on top of it at the moment. Well, they've had time, obviously, to get on top of it. So if you need that money, it's available to you, and the funds are processing it within around 3 to 7 days, I think is pretty standard, which is pretty quick for the super industry, believe it or not. The other benefit is that it's your money. So that's a huge positive, because you don't have to pay it back, and it doesn't come with any interest that's going to accrue and increase a debt. It's your money, and that's fine. So that's a real positive as well. And the other positive is that it's actually tax-free. So you know, you take $10,000 out of your superannuation account, and $10,000 arrives in your bank account for you to spend on whatever you need that money for. So there are a lot of positives to it, but there's actually some really significant negatives that well, in my opinion, outweigh that. But it really does come down to your personal circumstances. If you really need to access to those funds, and you're going to struggle to get them from anywhere else, then that's why the government has provided that access. The downsides, to be clear, are really, is super funds designed to grow your money to provide a decent retirement nest egg? It does that in two ways. One is that your employer and yourself can contribute to that account over time consistently. And just like a piggy bank, you keep putting $2 in it every week, and after 100 weeks, you've got $200. So I hope my maths is right on that. But the thing is, that's really the more simple part of growing that retirement benefit. The more complex part, but also the far more beneficial part, is that the super fund invests that money on your behalf into the stock market and into the financial markets. Now, that means that over time, that money is actually going to grow much faster and become much larger in the long term. Well, that's the idea, and I'll address that in a minute. But in the long term, than just simply putting it in a shoebox under your bed, which coincidentally is what my dad does. So he's got a lot of security there, but it's not going to grow particularly well for him. The thing is, as we have seen as a result of the pandemic, markets do fluctuate, and they do crash, and it's happened in the past as well. History suggests that markets tend to recover after a crash. How long that takes, it's anybody's guess, but that money is more likely to be beneficial and provide a better value for you if it stays in your super fund, if you can afford to leave it there for the long term while the market recovers from what's happened. So there's been some analysis that's been done by Industry Super Australia, and they've pointed out that by withdrawing $20,000 from your super account now, if you're 30 years old, then in effect, that means there'll be $100,000 less in your super by the time you reach retirement age. And if you're 40, the figure's around $63,000. So what that means is, while it might seem like $20,000 out of your account now, and that's certainly what it is, what it costs you in the long term, that really does depend on a number of factors, certainly the financial market, but more importantly, how old you are. So if you're 60 and that money was only going to stay there for a little while anyway, then it might have less of an impact than if you're 30 and it doesn't have the opportunity over the next 30 plus years to grow and become that $100,000. So it can have a really significant financial impact in the long term. And if you need to access it, then of course that's why it's there, and that's why these changes have come into play. But you need to recognise that, particularly if you're 40, 45 or younger, then it's not $20,000 you're taking out of your super account, because by the time you access it at retirement age, that will have grown, so it's significantly more that you're sacrificing. So people need to be informed about that. It might not change the fact that you still need to access the money, but you need to be aware that it's going to have a bigger impact over the long term. The other thing to be aware of is that it could impact your insurance entitlements if you're not careful. So with as an MS crowd, I'm sure a lot of you will be aware that through your superannuation fund, you're provided default life and disability insurance. So your total and permanent disability, or TPD insurance, and income protection policies are pretty common as well. And that's a really great way for someone with a pre-existing condition to have picked up some insurance that you might not have otherwise been able to get. So it's really important as an MS crowd to hang on to that and to understand that by accessing your super, you can put that at risk. The way you put it at risk, though, is actually just by zeroing your account. So if you take all the money out of your super account, there's no money left in there to pay for the premiums, and therefore you lose your insurance policy. So one way to reduce the risk is to make sure that if you are going to access your super account balance due to the pandemic, then you speak to your super fund first and you get a really clear understanding of how much money you need to leave in your account to make sure that those premiums continue to be paid and you can retain your insurance. So there's some other fine print and bits and pieces you should really be aware of or come to understand if you're unemployed for an extended period of time, because your insurance will certainly be impacted in terms of how you might be able to claim on it. I don't want to jump into that too much. Suffice to say, if you are going to access your super early, make sure you check how to retain your insurance entitlements, and also recognise that 20 grand now can actually mean a lot more and a big loss in the future if you're younger. So that's probably some of the things I'd say. Incidentally, also, if you are in financial difficulty and you're thinking about accessing your super, it's probably best to think of it certainly as an option, but probably a last resort kind of option, and instead maybe have a chat to a financial counsellor and see whether they can talk you through some of the other options, manage some debts and other things to try and make your way through this period of time without having to tap into that. They provide free and completely independent advice, and you can contact them via the National Debt Helpline on 1800 007 007. So it's really easy to remember because I just think of James Bond, but 1800 007 007.
That's a great number.
Free and independent advice. Yeah, and I highly recommend if anyone is struggling financially due to the pandemic or otherwise, then they're a really great free service to have a chat to and just understand your options.
Mm-hmm.
We also have a relationship with pro bono financial advice, and people get a bit suspicious about why our financial advisors providing free advice, but in this instance they actually are. So I can send everyone the contact details for that as well. There's some complex questions coming through, Rhys, in regard to taxation on super and accessing super and accessing TPD. Is it okay that we direct some people to you directly to have that more in-depth conversation?
Absolutely. Look, of course, we're providing some pretty general information here, and everybody's situation will certainly be a little bit different. So, really, more than happy to speak to anyone off channel and provide some more direct information and support there. In terms of tax, I think I'm not a tax accountant, so there might not be a lot that I can help with there. Suffice to say, if you're thinking about the early access through the pandemic clause, as we're calling it, the $10,000 or up to, then that's actually going to be treated as tax-free. So it won't be taxed when it comes out of the fund, and it won't be considered as part of your income or taxable income when you do your tax returns either. And your tax account will be across that. The ATO, if you're doing it yourself through the portal, that should all register as well. So from that perspective, tax should be less of a concern around that early access piece at least.
Thank you. Can TPD cover be increased after an MS diagnosis?
Oof, really good question. Look, you can certainly apply to your insurer, either directly or certainly if you will have insurance most likely through your super fund, and you can apply via your fund to increase cover. You certainly have a right to do that. When you increase cover though, you will be asked health questions, and you'll be asked to disclose any pre-existing conditions, and therefore it's likely that you could have MS and anything related to your MS excluded. So what that means is if you've got default insurance, so it's already provided and came to you when you joined the fund, that covers your pre-existing conditions in most cases. So that's $100,000 of insurance. I picked a random number. But let's say you want to increase that cover and you want another $100,000 added to that. The insurer or the super fund might reject that and say, no, we're not going to because of your MS. Or they might approve it and say, yes, we'll provide you with that additional $100,000, but that extra $100,000, we won't pay out for anything related to your pre-existing condition, in this case, MS, but you'll still be entitled to the $100,000, the original default insurance, if something was to occur. So in that sense, it'll be really difficult to get extra cover for your MS, but you could certainly get extra cover for non-related health issues, or if, God forbid, you're in a car accident or something unrelated to your MS, then that additional cover you've applied for, if it was approved, that would certainly still pay out if that was put in place.
Thank you. Christine's wondering what recourse does she have if her boss is not paying into her super?
Yeah, it's really interesting actually. Yeah, because it's not a oh, sorry. It's a bit of a quirky one because it's not always something that the employee themselves can pursue in court. It's something that it's like a debt owed to the ATO. So it's usually the ATO that has standing to pursue, as I understand it, that amount. If there's something in your the award that covers your employment, you might be able to commence some kind of claim about breaching that provision in that limited set of awards that do refer to the Superannuation Guarantee Act. But otherwise, I mean, my usual course is to speak with the ATO and see if there's anything that they can do. Is that your practice too, Rhys?
Yeah, look, in strictly contributions or lack of contributions, be that underpayments or no payment at all, then certainly lodging a complaint for underpayment or lack of payment with the ATO is unfortunately the limited sort of avenue you've got there. Interestingly, for me in the superannuation and insurance world, if your employer hasn't been paying any contributions, and as a result you never either joined the fund or certain triggers or gateways weren't met to provide you with that default insurance that we've been talking about, so TPD insurance, then if you became TPD, so for example, with your symptoms progressed to the point you couldn't work anymore, and you thought you're insured, or even if you didn't think you're insured, but you should have been, then we can actually go after your employer to say that because they haven't done what they were supposed to do, which is pay your super contributions, you're now not covered by a policy which you would have if they'd done their job or done what they were required to do, and therefore they're responsible for that loss, and we can actually ask them to pay out however much your insurance policy might have actually been if it had been activated through them making those contributions. So a bit of a convoluted process and probably a convoluted explanation, I think, but ultimately there are avenues there, particularly if you do get too sick and you can't work. You should have been able to make an insurance claim, but because they haven't paid you their contributions, you can't. Well, there's things that we can look at there for sure.
And Rhys, that's irrespective of whether the person has a contract or not, because that's a across-the-board requirement of employers, isn't it?
Yep,
exactly right.
Cool. What about the situation where someone has a doctor's letter of support to stay away from work, but the boss is making them attend work?
So it might be worth inquiring, if you can, with the boss about why they're still directing you to go. If you can, if you feel comfortable having that discussion, or asking a support person or your union to have that discussion about why they're still requiring you to go to work, even if they have, you know, this medical evidence, because it puts them at risk in a sense of, you know, if you're injured and you put them on notice about your particular vulnerability, they might be able, you know, you might have a workers' compensation or some other claim because it effectively puts them on notice about it and they've chosen to ignore it. If you're not getting anywhere, one option might be to make a application to the Equal Opportunity Commission on the basis that they're failing to take into account reasonable adjustments, and have some kind of conciliation process through that. But it really, I think, is going to, you know, in the immediate sense, it's worth asking why they're persisting with this direction. Do they need other evidence? Is it a business need? You know, having a conversation on a practical level, but there's certainly legal avenues as well in terms of making that application to the Equal Opportunity Commission or the Australian Human Rights Commission as well.
Thank you. I've got a comment and then a question. Sonia has told us that the ATO website has a tool which can tell you whether you're entitled to superannuation, and if you're entitled and not receiving super, you can make a complaint via the website. So that's great. And Mark's asked if I'll send information out. Absolutely, Mark. There'll be some contact numbers and details coming out. And then the question that is kind of connected to that is, why might superannuation payments stop during this time? Because that's the experience of someone.
Yeah, so the obligations for employers to provide to pay super guarantee contributions on your regular wages, certainly I can't imagine would have changed at all. If you're stood down, you're obviously not receiving any wages. Some businesses might be holding over what might be a regular super guarantee contribution payments. So, for example, if you're paid fortnightly, you get your wages and you also see that contribution go into your super fund. The obligation is actually, unless they've revised it again in the last 18 months or so, the obligation is to make super guarantee contributions on a quarterly basis at a minimum. It's not best practice. Obviously, when you get paid is best practice, but if businesses are feeling the pinch, they might choose to hold over super guarantee contributions and only meet that quarterly requirement. So that could be another reason. And then the other reason being that I'm not entirely sure, Jess, and you might be able to provide some light on this. I don't know whether JobKeeper payments are necessarily subject to super guarantee contribution requirements or not. So that could be part of the fact as well. But otherwise, beyond those, then it potentially is just an issue, and that your employers are trying to hang on to a bit of money to try and survive a very difficult time, but it doesn't change the fact that it's your entitlement and it should probably be paid to you.
Sonia's contributed, and this is my understanding as well, that yes, they are still required to pay superannuation.
That was my understanding too. Yeah.
Yep. So there's three of us in agreement. And not necessarily COVID related, but pros and cons of switching super companies.
Oh, actually, I just did that myself. So look, pros and cons of switching. Look, there's, from a financial perspective, it's really about doing your research, and if the fund, or there's a better performing fund that you're interested in joining, and you can get some good understanding and potentially some advice about the best performing fund, and that you think it's going to do better for you long term with those investments. That's certainly one factor. And then the other factor, though, for people with MS is certainly trying to retain that default insurance. So once you get that diagnosis, it can be very difficult to get cover other than through the default fund offerings. Switching a super fund, therefore, from where you're at the moment, and making an assumption that the insurance that's in place now does cover you for your MS. If you were to change funds now and chuck it in a different fund and close that one down, there's two things to be very careful about. First of all, making sure that any new insurance that comes into play with your new fund also covers you for MS. So in some cases, it won't cover pre-existing because you've elected to join the fund rather than join the fund with a new employer and become a default member. So it might not cover you at all. It might have an exclusion for pre-existing conditions for the first 12 months, for example, but then it might cover you. And then finally, making sure that whatever happens, that insurance, when it does cover you, if it will, you don't lose the cover you've got until that insurance with the new fund actually comes into play and will cover you, because you'll leave yourself exposed with no cover whatsoever. And then alternatively, you could actually hang on to both of them if you wanted to. But again, that means you're paying double the fees, double the premiums. And again, that's an area where you need to be seeking advice about what the best approach is for you.
Thank you, Rhys. I realise we've come to the end of our allocated time. In some respects, I've really only got one more question to ask, and that's around carers accessing their super if they've had to give up employment to be full-time carers. Is that possible?
Yeah, look, that's a really, really tough one, and I think it's a huge, huge gap in the legislation. So there's nothing specific around carers who give up employment and therefore for caring duties, and therefore allowing them to access super beyond the standard early access provisions. So be that financial hardship, compassionate grounds, or some of the others which are probably less related to caring duties. So in compassionate grounds, there may be some wiggle room, and that would be along the lines of accessing your super to pay for things like adjustments to your home or to your motor vehicle for yourself or a dependent to cater for a disability. There can also be things like transport to and from medical treatments, or the cost of medical treatments for yourself or a dependent that might not be covered through Medicare or other schemes. So there's ways to access funds to cover costs for yourself or a dependent if the person you're caring for is considered a dependent, as in a family or loved one or close friend, as opposed to a professional sort of role. And in this example, giving up work to become a carer full time, that certainly is the case. So, but that early access is really for specific and very strict criteria around accessing money to pay for certain things. It's not about making sure that you can dip into your super to pay for the groceries or cover your bills or other life expenses, unfortunately. So it is a bit of a gap.
Thank you. Rhys and Jess, there have been lots of thank you messages coming through as well, which is wonderful. I really appreciate you guys giving up your time today. It's been wonderful. And I would encourage everybody that's online to not feel that this is it. If another question comes up, please send it to us. I will put together the phone numbers that Rhys mentioned, and I'll put together the contact details for Rhys and Jess and how we go about getting further information. And any time, there's never a wrong time to ask a question. MS Connect is here for everybody. If the worst part of that might be that you have to leave a message, because if they're really busy, all the team there might already be on the phone. But please leave messages, ask your questions, that we will get back to you. We will connect you to the right people to get the answers to your questions. So thank you everybody for being online. Thanks for the fabulous questions that came through. If you didn't feel it was answered properly, please let me know, because there were a lot coming through and they get a bit disjointed. But my sincere thanks, Rhys and Jess, for your time today.
Thank you.
Absolute
Thanks for having me.
pleasure. Thank you, Andrea, and thanks everybody. They were some really great questions, and I'm sure there's probably a few more floating around as well. So we're really happy to hear any more of those. And if there are some personal circumstances that you need to discuss, then by all means get in touch. We're really happy to have a chat on the phone and see if we can point you in the right direction.
That's wonderful. Thanks, everyone. We'll look forward to seeing you at another webinar in the future. Bye-bye for now.
Thank you.
Thank you. Bye.